Hi everyone, I'm Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about no contest clauses. And do they really work, and does it really mean that no contest is no contest? Well, we live in a litigious society, we all know that. Unfortunately, even family members sometimes file lawsuits because they're dissatisfied with what their parents or loved ones leave them in a will or a trust. Some are so disgruntled that they decide to contest or challenge the validity of a will or a trust, which can then delay its administration for years and result in thousands of dollars in legal fees. If you're concerned that any of your beneficiaries may seek to challenge your will or trust, a no contest clause might be one method you can use to discourage them from pursuing this course of action. But let's first talk about what is a no contest clause. A typical no contest clause provides that a beneficiary who disputes the validity of a will or a trust will forfeit any inheritance or benefit they otherwise would have received according to its terms. It will not prevent someone who is not a beneficiary named in your will or trust from contesting it, though. So let's talk about whether no contest clauses are enforceable. Well, this really is going to rely on the state law of whether or not a no contest clause is enforceable. There's currently only one state in which no contest clauses are unenforceable, and that happens to be Florida. So let's talk about what some of the pros and cons are when it comes to no contest clause. Like most things, there's some advantages, but there's also some disadvantages. The pros of a no contest clause. First, it honors your right to give your property to whomever it is that you chose in any way that you want. And you've expressed this in your will or trust. So it discourages baseless challenges to your will or trust by some disgruntled beneficiary who you didn't want to leave something to, or you didn't want to leave what they thought they were entitled to. It also discourages meritless lawsuits aimed at forcing a settlement by someone who is a dissatisfied beneficiary, and it avoids lengthy and expensive litigation that will deplete your estate and delay the administration of your will or trust and all of your assets going to the beneficiaries that you've chosen. The cons of a no contest clause is that it might cause a beneficiary to suffer a loss or a forfeiture of his or her inheritance by enforcing his or her right to challenge the will's validity. It also impedes the court's ability to determine whether or not the will or the trust was valid and to ensure that it wasn't executed under some sort of duress. For example, when an unscrupulous child convinces an elderly parent with dementia to sign a new will or a trust that will be beneficial to that child, and that happens shortly before the parent's death. Let's talk about what legal actions would be considered a contest. A lawsuit that challenges the validity of a will or a trust or some of its terms are usually based on allegations of forgery, lack of proper execution, a lack of capacity, or perhaps duress or fraud or undue influence. And those are typically considered valid reasons for a contest. However, under some circumstances, a will or a trust could be considered to have been contested even if the beneficiary does not assert that it is invalid, but instead files a lawsuit that affects or changes the way that the money or the property is distributed or prevents the will or the trust from being administered according to its terms. An example of that would be challenging the method by which property is transferred into a trust. Now, some courts have found that a no contest clause has been violated even if a lawsuit contesting a will or trust is later withdrawn. So what legal actions will not be considered a contest? Although state law varies, certain types of lawsuits are typically not considered to be a contest of a will or a trust. Lawsuits brought to ask the court to interpret or construe the language of a will or a trust, or to determine whether a personal representative or a trustee has acted consistently with the terms of the will or the trust, are generally not considered to be a contest. And in addition, some states, the beneficiaries are allowed to first ask the court to determine whether a particular challenge would trigger the no contest clause. And those actions are typically not considered a contest that would result in a forfeiture of an inheritance to the beneficiary who actually filed the action. For example, in a recent court case, the trust beneficiaries that filed an alternative pleading, initially seeking a judgment as to whether a proposed claim would trigger a no contest clause, they were held not to have triggered the clause by filing the action itself. So let's talk about the possible outcomes of a successful will or trust contest. The outcome of a will or a trust contest depends upon several factors. If a will or a trust is declared invalid and there is no earlier will, then the deceased person's money and property will be distributed according to the state's law, which specifies how it should be divided up and distributed when there's no will. Now, when there's an earlier will, that will could take the place of the later one that has now been declared invalid. And if only part of the will or the trust is declared invalid, then the rest of that instrument will be upheld. And the intestacy law, the state's law, will apply only to the part of the estate not addressed in the valid portion. So let us help you create an estate plan that keeps the peace. If you see trouble brewing and you're concerned that family members could contest your will or trust, a no contest clause is one tool that could discourage dissatisfied beneficiaries from seeking to have your will or your trust declared invalid. And another possibility that could forestall a will or a trust contest is to conduct a family meeting during which you can explain your reasons for distributing your money and property in the way that you have or the way that you want. Allow us to help you create the best estate plan for your unique circumstances and to employ all of the available tools to decrease the possible conflict within your family. So give us a call to set up a meeting. We're happy to meet with you over the phone or a video conference or even in person if that's what you prefer. So I'm Kelly Longtin from Kelly Longtin Law, and I look forward to seeing you soon.